are live on John Crump News, where we talk about 2A stuff almost every day. By the way, check out Gideon Optics. They make great optics. Today, we're going to be talking about a new lawsuit that is challenging California's new Glock ban law. Let's go ahead and get into it. Welcome, guys. Today we're going to be talking about a new lawsuit that has just been filed about 30 minutes ago against California's Glock ban law. If you don't know what is going on in California, a bill was just signed into law by Gavin Newsom. And what that law does, it blocks the sale, import, or transfer of Glock pistols. The reason why California is saying that they are banning Glock pistols is because they are easily convertible to machine guns. So basically, they're making the argument that since you can buy a Glock switch off a Chinese website and mount it to your Glock, that makes all Glocks basically machine guns, which is a bunch of BS. Glocks are the most popular handgun in the country, and yet that is what California has targeted because that they're so popular. So, as of 30 minutes ago, or a little bit over 30 minutes ago, 3 gun rights organizations have teamed up along with 3 other people to sue California. Those gun rights organizations are the Firearms Policy Coalition, the Second Amendment Foundation, and the National Rifle Association. They are being represented by Cooper and Kirk out of DC, and they are suing the state of California for their Glock ban. I think that they have a good chance of winning because Glocks are definitely in common use. So we're going to take a look at the complaint here and talk about it a little bit. So give me 1 second here. Get this. All right, here we go. This is the complaint right here. And as you can see, it was filed by National Rifle Association, Firearms Policy Coalition, and the Second Amendment Foundation against Rob Bonta. Rob Bonta is the AG for California, and they are asking for a injunction against the law. They go over the Second Amendment, what the Second Amendment does and protects, and they reference Heller. Heller is where they said that things that are in common use cannot be banned, although we have been seeing the leftists try to spin that and say that what Heller actually says is that weapons that are in common use may be protected by the Second Amendment, but not necessarily protected by the Second Amendment, which is a bunch of BS. But that is what they're going with because they keep on losing on the whole entire Bruin thing. So they are basically challenging the constitutionality of Penal Code 2759.5, subsection A, which bans the sale or transfer of Glock and Glock style handguns with a cruciform trigger bar. Basically, it's not only affecting Glocks. Yes, Glocks is the brand, but it also affects anything that looks like a Glock. Basically, there's a bunch of Glock clones out there, from the daggers to the shadow systems. There's a bunch of Glock clones out there. The patent on the Glock Gen 3s ran out, therefore anyone can make basically almost anything like a Glock Gen 3 and some Glock Gen 4s as well. So all those are banned too, and they're all covered on this. Marconi Armory makes some really good stuff for Glock, so go ahead and check them out. They basically saying that the law is really unconstitutional, and I believe that it will. If you look down at section 4, it says California already bans many handgun models targeted by this law. This court has held that these restrictions are likely unconstitutional because these handguns are in common use. That was what was said in Rena v. Bonta, and that was applying to the Glock 43 and the Glock 17 Gen 5, among other handgun models, but those were the ones that was really, really covered in that case. And the court said that banning those guns in Rena was likely unconstitutional. And yet California turned around and they banned the same exact guns with this law. So the courts have already said that it's probably unconstitutional, and now they're doing the same thing anywhere. Um, Undeterred, the state is now expanding this ban on the popular handgun designed for self-defense. Plaintiff respectfully requests that this court declare this expansion is no more constitutional than the original ban and enjoin its enforcement. Basically, the other law got knocked down, so they passed this law and basically does the same thing. Plaintiff Danielle James is a natural person, a United States citizen, and a resident of California residing in the San Diego County. Plaintiff James is not prohibited under state or federal law from possessing, receiving, owning, or purchasing firearms. Plaintiff James possesses a valid certificate of eligibility issued by the California Department of Justice Bureau of Firearms. I don't think you should have to get a certificate of eligibility for anything, really. Plaintiff James makes occasional purchases of firearms, but for the law at issue in this suit, defendant's enforcement, therefore, Plaintiff James would, on or after July 1st, 2026, purchase handguns banned by the statute. Plaintiff PWG, doing business as Poway Weapons and Gear and PWG Range is a California limited partnership. PWG owns and operates a firearms retailer, shooting range, and training facility in the city of Poway within San Diego County. I'll be out in San Diego in about 3 weeks, 2.5 weeks. PWG is listed as a firearms dealer in California. DOJ centralized list of firearms dealer and is a federally licensed by the Bureau of Alcohol, Firearms, Tobacco, and Explosives as a federal firearms licensee. Open since 2011, Plaintiff PWG has lawfully sold thousands of handguns with cruciform trigger bars. These handguns, as discussed below, ban issue for its reasonable loss of his license under penal code, blah, blah, blah. The plaintiff's PWG on or after July 1st, 2026, wants to continue selling these handguns. Plaintiff PWG brings this case on behalf of its customers and would-be customers. So those are the two people that are joining the suit. Plaintiff John Phillips is the president of PWG and an individual licensee associated with PWG in California's DOJ centralized list of firearms dealers. Plaintiff Phillips brings this case on behalf of his customers and would-be customers. Then we go to the National Rifle Association, Firearms Policy Coalition, and the Second Amendment Foundation, which you all know. And then it goes into who Rob Bonta is. He's the AG of California, very, very anti-gun guy. Then it goes into jurisdiction. The jurisdiction is in California, and it is being filed in federal court in California. So they're stating that that is the correct jurisdiction. Now we're going to get into the meat and potatoes of things, the allegations. Plaintiffs bring this action to challenge the enforcement of California's cruciform trigger handgun ban in Assembly Bill 1127. So the ban doesn't actually ban Glocks; it bans any gun with a cruciform trigger bar, and that is the bar that a switch allows to slide over to turn it into a machine gun. Effective July 1st, 2026, licensed firearms dealers shall not sell, offer, for sell, exchange, give, transfer, or deliver any semi-automatic machine gun convertible pistol. So California is trying to call every gun with a cruciform trigger bar as a machine gun convertible pistol, which is a scary term for like a Glock. It's just a Glock. Within the statute contains few exceptions not relevant to this challenge for ordinary peaceable California. The law effectively closes the door on traditional commercial sales of these firearms. The exceptions, which it doesn't lay out here, is law enforcement is exempt from the law. So law enforcement can still get these guns. It's just that the dealers can't. And if you get caught selling one of these, you can get your license stripped. Then it goes into what it is. We already talked about that. Because the pragmatic handguns that meet California's definition of a semi-automatic machine gun convertible pistol are manufactured by Glocks, plaintiffs will refer at this time to the ban as Glock or Glock-style handguns. For the avoidance of plaintiffs are banned in the California statute. A pistol converter is a device that can be attached to a pistol, enables it to fire automatically, meaning it fires more than one round per single function of the trigger. What they're talking about there is the Glock switches. Put differently, a pistol converter is a device that transforms a semi-automatic pistol into a machine gun. Under California law, pistol converters are machine guns. They're also machine guns by federal law as well. Possession of a pistol converter is accordingly prohibited, and prohibition is not at issue in this case. This case is about whether California may ban semi-automatic handguns with a cruciform trigger bar, such as Glock and Glock-style handguns. All right, now we're going to get into the first cause of the action here. The plaintiffs incorporate, by reference, in the allegation in paragraph 1 through 24. The Second Amendment protects the right of the people to keep and bear arms, as it should. This fundamental right is fully applicable to the states through the 14th Amendment, McDonald versus City of Chicago. The 14th Amendment was ratified in 1868, and basically what it did is said that the Bill of Rights and the rest of the constitutional amendments also applies to the states. Before that, there was an argument that the Constitution only applies to federal law and state laws could do whatever the hell they want. The 14th Amendment cleared that up and said, no, it applies to everything. So the 14th Amendment really didn't change any of the constitutional amendments. It just affirmed that all amendments also apply to the states. McDonald versus the City of Chicago was a case that Mr. McDonald, who passed away sadly, brought up. It's one of the key Second Amendment cases, and dealt with Chicago and the. I'm gonna do another video on it, but Mr. McDonald was a great guy, and yeah, it's sad that he's gone. The biggest cases are Ezell versus City of Chicago, McDonald versus City of Chicago, Heller, Bruin, and there's a few other. Rahimi might go in there because it said you can only temporarily disarm people. But let's get back into this case. Textually, the right to keep and bear arms weapons include the right to acquire them. As Heller made clear, the only historical justification that could be used justifying the ban of a firearms is that the firearms is both dangerous and unusual. Arms that are in common use are, by definition, neither. Thus, in Heller, the Supreme Court held that the Second Amendment protects and the possession and use of weapons that are before. As I said before, the anti-gun side is trying to make an argument that Heller actually said that only arms that are common use are protected by the Second Amendment, but not all arms that are in common use are protected by the Second Amendment, which is a bunch of BS. And it's really grasping at straws because they've been losing so much that they are trying to change the rules. A law that bans the sale of and in corresponding prevents citizens from acquiring a weapon in common use violates the Second Amendment. Semi-automatic handguns with cruciform triggers are not different from any other type of semi-automatic handguns in a constitutionally relevant way. The Supreme Court has already held that handguns are in common use and cannot be banned. Handguns are the most popular weapon chosen by Americans for self-defense in the home, and a complete prohibition of their use is invalid. That's actually from Heller. That quote is from Heller, if you're wondering. Semi-automatic handguns, including those with cruciform triggers, therefore cannot be banned, even considered as their own group, which under Heller, they should not be. The banned handguns are constitutionally protected. So they're what they're basically saying is, like, even if you separate handguns with cruciform trigger bars out, there's so many of those like that that it's still fall into common use. And that's what 37 just said. Maybe I should have read that first. And then it goes into how Glocks are the most popular handguns in the world. And it even quotes the FBI. Uh, in in 2021 alone, Glock manufactured 514,838 handguns for sale in the United States. That's to say nothing of imports. In 2021, 263,341 handguns were imported into the United States. Of those, 1,688,941 was imported from Austria, where Glocks are manufactured. It's therefore likely that in 2020 alone, Glock imported hundreds of thousands of handguns for sale in the United States. The handguns banned by California are rarely available for sale throughout the United States. To the best of plaintiff's knowledge, Massachusetts is the only other state that bans the sale of Glock's handguns. Bans that's Penal Code blah 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 bans the sale of constitutionally protected handguns and violates the Second Amendment. The defendant's enforcement of the statute therefore deprives the citizen deprives of the rights here in the Constitution. Now, this is what they want. They want them to declare the law unconstitutional under the Second Amendment, both facially and as applied. So basically, knock down the law totally and also as applied to the plaintiff. And they want to enjoin the enforcement of the ban of the handgun. So basically, tell California to go pound sand, they can't ban it. And then they want attorney costs from California. And of course, there's always this catch-all that everyone throws in there that says any other remedy that the court sees fit, basically. So that is what's going on. This is a big suit, and I think these gun groups have a huge chance of winning this because this law flies in the face of everything. Where is Rich? I don't know. The California law, I believe, is facially unconstitutional and as applied unconstitutional. So I think this is going to be a win for these gun rights organizations, and I don't think it's going to be the last case that we see on this. I believe that there's going to be other cases popping up suing California over the same exact thing, and I believe that California knows that they're going to get sued and they're probably going to lose, but they passed a law anyway to do lip service to the anti-gunners out there so they can keep on getting money. And they know that they might not be able to stop it forever, but they will be able to slow down the sale of Glocks a little bit because these cases take a long time to work their way through the court system. What they're going to do is they're probably going to lose at the district court level, and then they're going to ask for a stay, which will probably be granted, and they'll go to an en banc review where they'll probably lose again, and then they'll ask another stay, which will be granted, and then it will go to the Ninth Circuit, which I don't see how the Ninth Circuit could rule for California. So let's just assume that they don't rule for California. They'll probably stay their own decision until it gets up to the Supreme Court or the Supreme Court decides not to take it. So, and they know that. So the whole entire thing is to delay, and to cause stress on the firearms community and also on the firearms companies. They know that they're going to lose, but they can delay it as much as possible. All right, guys, that is it. Just wanted to make a quick video. I saw this come down and wanted to tell you all about it. Once again, if you have an extra couple bucks kicking around and you want to help out the scouts, you can do that. You can donate to PAC 997. PAC 997 is a great scouting organization. It is a traditional scouting organization where we are boys only, teach about God and values and stuff like that, uh, conservative values and stuff like that. We concentrate on camping and growing boys into men and to teach them responsibility and everything else. So if you want to help us out, you can do so by going to givesendgo.com/997. That's givesendgo.com/997. We are running below where I would like us to be, but I understand times can be hard sometimes. So if you have a couple extra bucks kicking around, go ahead and donate to us. givesendgo.com/997. You can also share that out with anyone. If you can't really afford it, you can say, hey, let's bring the scouts back to what they once were. All right, guys, that is it. We're going to get out of here. Thank you guys so much. And with that, we are gone. Bye.